The Madras High Court has delivered a landmark decision. This verdict establishes a clear and non-negotiable rule for all forms of dispute resolution. It declared that an arbitral tribunal must strictly adhere to the foundational principles of natural justice. This mandate holds true even when the tribunal is an informal body composed of family elders. This case concerned a family dispute where elders were chosen to arbitrate, but their process was later challenged in court. The court's decision is profoundly significant. It directly impacts countless families across the nation that traditionally turn to respected elders to mediate and resolve internal conflicts, seeking a quicker, more harmonious alternative to formal litigation. The court's ruling serves as a critical reminder. It underscores that informality does not grant a license for unfairness. Arbitration is a method of resolving disputes outside the formal court system. This process involves the parties mutually agreeing to appoint one or more neutral individuals, known as arbitrators, to make a binding decision. In many communities, families appoint elders to this role, leveraging their wisdom, experience, and deep understanding of the family's history and dynamics. At the heart of the court's decision lies the concept of natural justice. In its simplest form, natural justice is a procedural guarantee of fairness. It is not a complex web of technical legal rules, but rather a set of fundamental principles that ensure an orderly and equitable decision-making process. An arbitral tribunal is a private, non-governmental body chosen by the parties to adjudicate a dispute. Natural justice can be distilled into two simple yet powerful rules that govern how such tribunals must operate. Understanding these rules is crucial for anyone involved in arbitration, particularly within the sensitive context of family disputes, where emotions can often run high and pre-existing relationships can complicate matters. The first fundamental rule is the hearing rule, audi alteram partem, hear the other side. Every person must be given a reasonable opportunity to present their case, being properly notified of the proceedings, understanding the allegations or claims made against them, having the chance to respond with their own evidence and arguments. No one should be condemned unheard. Decisions should not be based on incomplete or one-sided information. That promotes a more thorough and accurate understanding before a conclusion. The second core principle is the bias rule, nemo judex in causa sua. No one should be a judge in their own cause. The arbitrator must be impartial and disinterested. The practice of appointing family elders as arbitrators is rooted in a desire for swift, culturally sensitive, less adversarial resolutions. Families often believe that elders, with their intimate knowledge of family dynamics and traditions, are best positioned to find solutions that preserve relationships. While this approach has many benefits, the Madras High Court's ruling highlights the inherent dangers when procedural fairness is overlooked. The emotional landscape of family disputes is often complex and volatile. Long-standing grievances, personal loyalties, unequal power dynamics can easily cloud judgment and lead to decisions that feel deeply unjust to one or more parties. The rules of natural justice become critically important in this specific context. Family arbitrators may unconsciously favor one member over another due to a closer personal bond or a pre-existing perception of the individuals involved. The hearing rule, for instance, prevents an elder from making a decision after speaking to only one sibling or relying on second-hand information from a favored relative. It forces a structured process where everyone gets an equal platform. Likewise, the bias rule is a safeguard against an elder's potential conflicts of interest. Without these formal checks, an arbitration can devolve into a one-sided conversation, leaving the marginalized party with a profound sense of betrayal and injustice. When these fundamental rules are ignored, the entire arbitration process is put at risk. A party who feels they were not given a fair hearing or that the arbitrator was biased can challenge the resulting award in a court of law. To truly appreciate the importance of natural justice, consider a simple, hypothetical example that illustrates what can go disastrously wrong. Imagine two brothers, An and Balan, who are in a sharp disagreement over the inheritance of their late mother's ancestral home. To avoid a lengthy and costly court battle, The family agrees that their eldest and most respected uncle, Chandran, will act as the sole arbitrator and decide who gets ownership of the property. Everyone trusts Chandran's wisdom and hopes he will provide a fair solution that everyone can accept, thereby keeping the peace within the family and honoring their mother's memory. Chandran begins the process with good intentions. However, he lives closer to Anand and has always shared a more comfortable rapport with him. He arranges a meeting with Anand at his home to discuss the matter. During this private meeting, Anand presents his side of the story, explaining why he believes he is the rightful heir and providing documents he claims support his position. Chandran, feeling he has a good grasp of the situation, decides not to bother Balan with a formal meeting. He believes he already knows Balan's perspective from casual family conversations and doesn't want to create more tension by forcing the brothers into a confrontational setting. A week later, Chandran issues his decision. He awards the house to Anand. He does not provide any written reasons, simply stating that his decision is final and in the best interest of the family. When Balan receives the news, he is devastated and feels utterly betrayed. He was never given a chance to formally present his arguments, see the documents Anand provided, or even know that a decisive meeting had taken place. The process was opaque, and the outcome feels predetermined. Beyond the right to be heard, the principle of neutrality is the second pillar supporting a just arbitral process. The bias rule insists no person should be a judge in a matter where they have a personal interest. This is particularly challenging in the context of family arbitrations. Elders chosen as arbitrators are, by definition, not strangers. They are woven into the very fabric of the family, with a web of relationships, histories, affections that can subtly or overtly influence their judgment. This inherent closeness, while a source of wisdom, can also be a significant liability if not managed with care and transparency. Let's revisit our cautionary tale, but with a slight variation. Suppose Uncle Chandran did, in fact, give both Anand and Balan a chance to speak. He holds a formal meeting where both brothers present their cases. However, what the family does not widely know is that Chandran's business is heavily dependent on a loan he received from Anand years ago. Anand has been generous with the repayment terms, and Chandran feels a deep sense of gratitude and obligation towards him. Even if Chandran consciously tries to be fair, this financial entanglement creates a powerful subconscious pull. It creates an appearance of bias that can taint the entire proceeding. In this scenario, if Chandran rules in favor of Anand, Balan would have strong grounds to challenge the award based on the bias rule. The legal test is often whether the circumstances would lead a fair-minded and informed observer to conclude there was a real possibility of bias. The financial relationship between Chandran and Anand would almost certainly meet this threshold. The Madras High Court's ruling is not just a warning, it is also a guide. It encourages families and their chosen arbitrators to adopt simple, practical steps. Ensure the process is fair and the outcome durable. These measures do not require legal expertise. They are common-sense actions aligned with natural justice. First, ensure proper communication. All parties must receive clear and timely notice. Date, time, place, purpose. This prevents anyone from being excluded and satisfies the hearing rule. Second, transparency in documentation. Share any document with all parties. Document, letter, piece of evidence. There should be no secret evidence or private submissions. Everyone must work from the same information. Third, conduct the hearing fairly. Give each person an adequate opportunity to speak, present their side, call witnesses, respond to arguments. Arbitrators must listen patiently, without interruption. Fourth, avoid private communications about the dispute. Hold substantive discussions in front of all parties. Avoid ex parte contact to preserve impartiality. Fifth, communicate the decision in writing. The written award should provide reasons. Explain why the tribunal reached its conclusion. In conclusion, the decision from the Madras High Court is a powerful affirmation of a timeless legal truth. Fairness is not a technicality, but the very essence of justice. By stating unequivocally that family elder tribunals must follow the principles of natural justice, the court has not weakened this traditional system, but strengthened it. The practical effect of this verdict is to create a more reliable and trustworthy framework for resolving intra-family disputes. It provides a clear takeaway for families. Embrace the wisdom of your elders, but ensure their process is grounded in the fundamental rules of a fair hearing and impartiality. This approach is the best way to ensure that their decisions are respected and upheld. For lawyers, the message is to advise clients proactively. When drafting arbitration agreements for family matters, they should now incorporate simple clauses that outline these basic procedural guarantees. Ultimately, this verdict has a profound impact on public trust. By insisting that even the most informal arbitrations adhere to basic fairness, the court elevates their legitimacy. The final clear takeaway is that fairness is never optional. It is the essential ingredient for lasting peace.